Another element is the possibility of performance. A contract must be physically and legally capable of being performed. A contract will be void if it was impossible to form at the time it was entered into. A contract may be voidable where performance becomes impossible only after the contract was concluded. For a person to escape liability for a contract due to impossibility, they must prove to the court the following 4 elements relating to impossibility. The impossibility of performance must have been due to either vis major or causus fortuitus. Vis major refers to acts of nature, acts of God, and causus fortuitus refers to inevitable acts of an irresistible force, such as the acts of a state or government or disease or death. Think of the Disaster Management Act. The impossibility must be absolute. There must be no way that the contract could possibly be performed by any other person. That is, if anyone else could have performed the contract, the court will not recognize that performance was possible. The person claiming impossibility must not be responsible for the impossibility. The impossibility of performance must not have been foreseeable. By contrast, speculative contracts foresee the possibility of failure and inability to perform. For example, farming contracts foresee the possibility of drought. South African law recognizes 2 categories of impossibility: physical impossibility and legal impossibility. Physical impossibility is when the contract is not physically capable of being possible when the contract is first made. Contracts are void if performance is objectively impossible at inception. The contract may be rendered void if performance becomes impossible after the contract has been concluded. I know this is a lot, but you get different forms of impossibility. Objective impossibility. This is if a contract is impossible for anyone in the world to perform. The contract will be void. Supervening impossibility. This occurs where the impossibility occurs as a result of an act of God, an act of the state, or an irresistible force that is beyond the control of either party. For example, if Sally entered into a contract to sell Billy 100 bottles of gin during the lockdown level pandemic 5, there would be a supervening impossibility owing to the fact that the state prohibited the sale of alcohol. Finally, you get legal impossibility. Agreements to commit crimes or delicts or break the law are void and invalid in terms of the common law. Agreements to injure the state, obstruct the course of justice, or defraud the public are also invalid. We will now consider formalities of a contract. The general rule is that no formalities are required. Valid contracts can be made orally in written form or even by conduct. As long as the intention of the parties is communicated clearly, then an oral contract is generally valid, as is a written one. However, some formalities are prescribed by law. For instance, the law may require that some contracts must be reduced to writing, such as an agreement to sell land. In this regard, the importance of the Alienation of Land Act must be considered, as it notes down all the requirements of a contract when alienating land. If any party later believes that the written agreement does not reflect the intention of the parties, the party may apply to court to correct the document. This process is known as rectification and may be used to remove a term mistakenly inserted into a contract or to insert a term mistakenly omitted. The court may also apply the doctrine of rectification where a document wrongly records the identity of a party. Furthermore, the law may require that some contracts must be signed in front of a specialist attorney called a notary public. This refers to notarial execution. The failure to comply with a statutory formality will generally result in the agreement being void, and any performance may then only be recovered under the doctrine of unjustifiable enrichment. Some statutes, however, provide that if certain formalities are not complied with, then the agreement may be valid but unenforceable against third parties. In some situations, the agreement may be valid, but the parties may be criminally liable. One can also self-impose formalities. This could include a non-variation clause, which typically provides that no variation of the written contract is of any legal effect unless the variation is in writing and signed by both parties. When interpreting contracts, our law tries to give effect to the true intention of the parties at the time the contract was concluded. However, it can sometimes be very difficult for a court to determine this intention when dealing with parties who are in a dispute over the meaning of words in their agreement. There are, for instance, express, tacit, and implied terms. Express terms are explicitly stated either in writing or verbally. Implied terms are simply the duties imposed by the parties by law, precedent, custom, or trade usage. They are not dependent on the actual or presumed intention of the parties. Tacit terms can either be consensual or imputed. Consensual tacit terms relate to matters on which the parties had actually reached agreement or had a common expectation, but failed to express in writing or speech. For instance, the parties may have intended to add certain terms into the agreements, but simply omitted to do so. These terms will then be read into the contract as if they were originally part of the contract. Imputed tacit terms are terms concerning matters the parties had not considered, but they would have agreed to the term if their attention had been drawn to it at the time they entered into the contract. When it comes to interpreting contract, the parole evidence rule is very important. This rule means that where the court is interpreting a written contract, no oral or other evidence may be received by the court that tends to contradict, alter, add to, or vary the written terms. Similarly, where the terms of a written contract are clear and unambiguous, no evidence may be given to vary their plain meaning. The exception is that in the cases where ambiguous words are used, or where words are used in a technical or special sense, extrinsic evidence is admissible to explain the broad context in which the words requiring interpretation were used in the document. When interpreting a contract, the following presumptions of substantive law will apply, unless the contrary is proved. The parties have contractual capacity to enter into a contract. Each party acts as a principal in their own name. If the words are ambiguous as to whether the party contracted for him or herself, or for a third party, or as an agent, it is presumed that the party acted for him or herself. Parties wrote what they intended and expressed themselves truthfully in the documents. Where a contract comprises more than one document or contains extra information, it is presumed that the parties intended the extra words or information to be contractual terms. The object of the contract is lawful and performance will be made in accordance with the law. This means that all necessary formalities have been complied with. And where a contract is capable of conflicting interpretations as to lawfulness, it is presumed that the parties intended the lawful interpretation be implied. The parties did not intend for any provisions to be unnecessary or meaningless, but intended an effective contract. The contractual arrangement is equitable between the parties, since contracts are based on good faith. It is presumed that neither party intended an unfair or inequitable advantage over the other. The contract should have no retrospective effect unless it is expressly stated. Where reciprocal obligations are imposed on the parties, it is presumed that these are performed simultaneously. The contract is presumed to be unconditional, and a party who alleges the existence of any condition must prove this. Where it is uncertain whether the condition is suspensive or resolutive, it is presumed to be resolutive. Where a money debt is payable at a future date, the debt may be paid in advance by the debtor, but the creditor cannot claim repayment until it is due. Where written words conflict with printed words, the written words will prevail. Furthermore, note that as previously mentioned, courts are reluctant to allow extrinsic evidence to be presented to explain or contradict the plain meaning of words. With that being said, the courts have now adopted a less formalistic approach to the admissibility of extrinsic evidence for the interpretation of contracts. Now, even when and where wording of a provision is such that the meaning seems apparent to a court, evidence of background circumstances may be admissible for the purpose of understanding its meaning.